Hi everyone, I'm Kara Carlson, your host for today's webinar on Revocable Living Trust. I'm speaking to you from our office in Reston, Virginia. Joining me is Carrie Clark, the Senior Relationship Manager for North Carolina. We have about 30 minutes of slides for you today, and then we'll leave plenty of time for your questions. Since you are muted, please ask your questions by typing them into the questions block on your screen. This monthly webinar series is brought to you by AAFMAA Wealth Management and Trust. We are AAFMAA's trust company. AAFMAA stands for American Armed Forces Mutual Aid Association and is the longest-standing not-for-profit association that empowers military families with affordable financial solutions. We accomplish this by being the premier provider of financial planning, investment management, and trust services for the military not-for-profit. Also, as a trust company, we have an additional legal obligation to act as your fiduciary, which means we only act in your best interest and for your benefit. Here's an important disclaimer. This presentation is educational. It is for general information only and is not specific investment, legal, or tax advice for any of you individually. Do not rely on this presentation alone to guide your financial planning decisions. Since each individual situation is unique, your needs for financial services will differ. For individual advice, please contact us directly. We produce this webinar series in-house with our own professional staff as a service to our members and to help them better understand the resources that are available. In this case, today's presentation will focus on one of the services we offer, Revocable Living Trust. I will now turn it over to Carrie to go over the agenda, and we'll be back at the end for questions and answers.
Thank you very much, Kara, and good afternoon, everyone. Thank you for joining us. We'll start with today's agenda. We're going to start by talking about Revocable Living Trust and the fundamentals of Revocable Living Trust. Next, we'll move on to the structure of a Revocable Living Trust. We'll discuss why individuals choose to draft and use a Revocable Living Trust in their estate plan. We're going to talk about some scenarios where Revocable Living Trusts work well for our members, and we'll conclude with questions that you can type into the question box and we can address. So the basics of a Revocable Living Trust. A Revocable Living Trust is a legal trust document drafted by an estate planning attorney with three principal parties to the document. The first party is the grantor. That is the individual or individuals. Oftentimes we see husband and wife drafting together, but it can be just husband, just wife, or just an individual. The trustee. During the lifetime of the grantor, it is common to see the grantor and their spouse serve as joint trustees, or one of the spouses serve as the trustee. But it is also possible to name an independent trustee, be that a trusted family member or a corporate trustee. Again, the flexibility of this being a revocable living trust is that you can name your own trustee or serve as your own trustee. And finally, the beneficiary. Again, during the lifetime of the grantor or grantors, the beneficiary is typically the grantor. But after the death of the grantors or the second to die, they name beneficiaries that will their estate will pass to their heirs. So a revocable living trust is created by the document through an attorney and is funded during a grantor's lifetime and can be changed or revoked at any time while the grantor is living and has mental capacity. A revocable living trust can be a key estate planning tool. They provide seamless management and administration of assets in the event of the grantor or trustee's incapacity when a successor trustee is named. The structure of a revocable living trust is that it facilitates transfers to others. The beginning during the grantor's lifetime, the beneficiaries, like as I mentioned, are the grantors. Assets are housed or titled to the revocable living trust. it's very important that the assets be appropriately titled to the trust. If you would like for your home or your bank account or investment account to be part of the trust, you have to re-register and retitle those assets in the name of the Revocable Living Trust. Intent doesn't count in the end. So if you intended for your house to be an asset of your Revocable Living Trust, but didn't file the appropriate transfer deed paperwork with your local register of deeds for the property title, then it is not an asset of your Revocable Living Trust. And upon the death of the grantor or grantors, the assets of the Revocable Living Trust can be used to pay taxes, final expenses of the grantors, and then can pass to charities of your choice or your beneficiaries, your heirs, your children, grandchildren, nieces, nephews, whatever your particular financial circumstances and wishes are. And in doing this, you achieve very beneficial results. You can avoid probate. You can provide for the continuity of your asset management. You maintain privacy. Probate process is a public process. And so if you don't want your next door neighbors to know about the wealth that you've accumulated during your lifetime and you'd like to avoid that invasion of privacy, a Revocable Living Trust will help avoid probate and therefore not make your private financial affairs public. And finally, it designs a long-term distribution plan for your family members and charities as your heirs. So why do our members use Revocable Living Trust? The two big reasons are succession or life events. And we'll start with succession. Again, as I mentioned, it avoids probate and the complications that can come with probate. Probate is governed by state law, and every state has a unique and different probate process. Some states' probate is relatively simple, inexpensive, and efficient and quick. Other states, on the other hand, it can be very costly and very time-consuming for your executor or heirs. And again, there's the privacy issue with probate. Revocable Living Trusts can help manage spendthrift heirs. So the term spendthrift is a term that we use in the trust industry for heirs that have not been able to successfully or responsibly manage their own finances. And the trust can be drafted in such a way that distributions to those heirs are controlled, and furthermore, it can protect the assets in the trust from the creditors of your heirs. Finally, it can provide for your dependents, so the trust can deem that it is to, the assets are distributed to your dependents upon your demise. Life events that occur that a Revocable Living Trust is useful for is incapacity. It's a big one. So when an individual drafts a Revocable Living Trust and they're serving as their own trustee during their lifetime, if they were to become incapacitated and unable to manage their own financial affairs, be it dementia or Alzheimer's sets in, the trustee, the successor trustee named in that document, can step in and will step in and serve in their absence very seamlessly. An alternative is usually a power of attorney, and we found, and I'll discuss this in a future slide, that powers of attorney can be cumbersome to get financial institutions to accept. Back to confidentiality, again, probate is not a confidential process, so a Revocable Living Trust avoids that breach of confidentiality. And finally, should the trust, the Revocable Living Trust that you draft, become unnecessary due to life events, it can be revoked and all of your assets can be removed. This flexibility is often appealing to people that don't want to tie up their assets or irrevocably gift their assets to a trust and not have access to them in the future. So we have a few scenarios that are very common for drafting and using revocable living trust. And the first one we'll touch on is where a grantor owns real estate in multiple states. So if you own your primary residence in one state and maintain a vacation home, a beach home maybe, in another state, having assets in two states subjects your estate to ancillary probate. And that requires that your executors open a probatable estate in both your state of residence and the state where your additional property is. This can definitely cause additional costs and work to settle your estate. Depending on who is serving as your executor, they will have to work with two different states and coordinate between two different sets of probate parameters and laws. And it can be costly. It can also slow the process down and hold your heirs up from receiving their inheritance. And finally, depending on the state where you have additional property, it can that state may have estate or inheritance tax, so it can further reduce the value of your estate and what can pass to your heirs by having to pay those estate and inheritance tax through the ancillary probate process. The second scenario is property management in the event of incapacity. So I touched on that as a reason, but we'll go a little deeper into why that is important. So if you wish to have someone continue to manage and oversee your assets and to make distributions in the event of your incapacity, a revocable living trust can do that with ease and simplicity. Financial institutions these days are bound by very strict guidelines in general, but even more so with accepting powers of attorney. And powers of attorney are state-specific, and different states have very different laws about what is required for a power of attorney to be deemed appropriate in that state. If you drafted in a power of attorney 15 years ago, your state law could have changed, and that power of attorney may not be acceptable any longer in your state. So the person who is going to step in and manage your financial affairs in the event of your incapacity could encounter great difficulty in taking control of those assets. If those assets are needed during your incapacity for distributions for your care, there can be a huge lag time in the ability for that power of attorney to gain control of the account and request distributions on your behalf. Furthermore, they can't control the investment management, so they can't change the structure or allocation of the investment that may be more appropriate given your incapacity and your need for those assets. And the third and final scenario is asset management in your absence. So while you have a revocable living trust, if you're serving as your own trustee, you typically are responsible for the asset management of the assets that you've put in the trust. If at any point in time you decide that you want to retire and not bear the burden of managing your investable assets, or you don't have any expertise, naming a successor trustee that can act in that capacity and perhaps has a professional, the professional management skills. If it were a corporate trustee, they can relieve you of those duties. More importantly, we see with joint revocable living trusts where both husband and wife are grantors and trustees, if one of the spouses passes away and the surviving spouse is not the spouse that has been making the financial decisions on behalf of the family, they can be unfamiliar and uncomfortable with making these investment decisions, and the trust can provide that a successor trustee assume that financial management. The successor trustee could be another individual, and as you're drafting your trust, you would want to consider that the successor trustee as an individual be someone that has knowledge of financial management, or it could be a corporate trustee where they do have that professional expertise. So there are some reasons to consider a corporate fiduciary. Again, I just touched on the professional experience and expertise. Not only do they have the experience and expertise in the investment management realm, but also in trust accounting. They have the systems and the record keeping to provide the accounting of that trust and prepare the tax work that's required for trust. Trusts have what we call dual ledger accounting. So the assets that you put into the trust are the principal assets of the trust. And the income or the earnings or gains on those assets become the income of the trust. And the principal and the income are separate ledgers in an accounting system, which is sometimes difficult for an individual to maintain, whereas a corporate fiduciary has the right systems and software to maintain that dual ledger accounting. Finally, by nature of being a corporate fiduciary, a trustee is bound to be impartial and objective. So all decisions made are always in the best interest of the beneficiaries and subject to the grantor's intent and wishes in the trust document. Trustees may not impose their own personal standards on distributions to beneficiaries or treat one class of beneficiaries differently than another. And they have a duty of loyalty to the trust and to the grantor. It gives you peace of mind that your assets and your succession of your assets to your heirs is done fairly, impartially, objectively, and with loyalty to you. And finally, there's no risk that a corporate trustee could fail to act. With an individual, illness could set in, age, you could have if your trust were to go on for years after your passing, the individual you name may also become, elderly or incapable of managing the trust, or personal issues that could come about when you have an individual serving. Many people name one of their child or children as the trustee, and as your children develop careers and develop families, managing the assets of the trust can be cumbersome, whereas a corporate fiduciary has the expertise and the staff on hand that there is a consistent management of your trust and its underlying assets. So to summarize what we've just discussed, the benefits of a revocable living trust are the provisions for your incapacity, control of assets both during your lifetime and after your death, the avoidance of probate, and privacy. One final slide. I'm not going to go through all of the points on this slide, mention a few, but as people are seeking attorneys to help them draft a revocable living trust if it's appropriate for their situation, it is important that you understand the terms of the trust that have been drafted, and that nothing that you have drafted is inapplicable to your own personal financial situation. And these are some of the things that you could discuss with an attorney as you're drafting your trust to be sure that it's drafted to comply to your wishes and the inheritance and succession that you wish. A couple that I'll touch on are, and I mentioned earlier, the spendthrift provision. So is there a spendthrift provision in your trust? Just because you draft in your trust that your assets are to go to your son or daughter does not necessarily protect those assets from their creditors. There has to be specific language and specific distribution terms that allow for those assets to be protected. Something we see very often, and we speak to it in our business as the future ex-son or daughter-in-law situation. And certainly, this is not something that I wish upon anyone, but it happens where sometimes marriages fail, and you have drafted your trust so that your son or daughter receives the assets upon your death. In the event that there was an unfortunate divorce with your child and their spouse, without particular language to protect those assets, they could become a marital asset, and the future son, ex-son-in-law, or ex-daughter-in-law can and likely will receive some of those assets in a divorce proceeding. So the spendthrift provision, if appropriately drafted by an attorney in your document, can prevent that. And another important one that I'll touch on is the second to last bullet point: are the trust assets liquid or illiquid? We mentioned that many people draft a revocable living trust to avoid that ancillary probate. If you draft a revocable living trust and the only asset that you put into the trust is that second vacation home in another state, there will be some complications at your death. And the reason for that is because real estate is considered an illiquid asset. It takes time to sell it on the market and to go through settlement processes. If you wanted that piece of property to be maintained for your family, for future vacation, for your children and grandchildren, and there are no liquid assets, a trustee would have difficulty maintaining the property, paying property taxes, real estate, or homeowners insurance, and providing any maintenance that would be needed to upkeep that property. So it is important that when you draft a revocable living trust, that there are some liquid assets, and those would be cash or marketable securities that are easily liquidated on the stock exchange or general market, so that those expenses of the real estate itself can be covered. So with that, I'm going to turn this back over to Kara to moderate some questions that you all have, and hopefully we can give you some answers. Kara?
Great. Thanks so much, Carrie. That was a great discussion on why someone would need a revocable living trust. We've collected a few questions already, but please don't hesitate to ask others by typing them into the questions block on your screen. As a senior relationship manager, Carrie is one of the wealth management professionals around which we build our client service teams. Depending upon your personal needs, those teams might also include a financial planner, investment officer, trust officer, or account administrator. I'll go ahead and leave her contact information displayed here while we go through the questions and answers. All right, Carrie, first question. If when I'm gone, something happens to my wife, how do you take over as successor trustee? Is someone supposed to notify you if she's in the hospital or passes away?
Okay, great. Thanks, Kara. Yes, it would be, if we were named in the document as successor trustee, it would be our responsibility to take over after the second to die of husband and wife. but we would need to be notified. We certainly would have probably no way of knowing that the second, the surviving spouse was in the hospital or has passed away. And therefore, what we recommend is that as you are discussing with your heirs, your estate plan and succession plans, that you keep a current list of your advisors, and that way your heirs know who to contact in the event that something, a life event like a hospitalization, incapacity, or a death occurs.
Great, thanks, Carrie. Next question, how much does creating a trust cost? Can you help with this?
Okay. We are a corporate fiduciary. We are regulated by the state of North Carolina to provide trust services, but we cannot provide legal advice. While we have in-house counsel, it would be considered a conflict of interest for us to draft trust documents. So we cannot help with creating a trust. We certainly would like to work with our members to help them identify an estate planning attorney that can help them and work through the process with the member and the estate planning attorney to ensure that a trust is drafted that meets their needs and their succession goals. As far as cost goes, that varies by region and certainly varies by the complexity of the trust. Some people have what we call plain vanilla trusts, which is the trusts are in, the Revocable Living Trust, and at my death they go outright to my 2 children, 50-50. If there's real estate or perhaps business interests, the attorney will likely have to spend more time customizing the trust, and that can cause additional cost. So as I said, we cannot provide legal advice, and the cost can vary based on where you live. And I've seen the costs vary anywhere from, at the lowest point, $2,500 to well over or close to $20,000. So it can vary, but we do encourage you to work with an estate planning attorney. And if any of the reasons that I've suggested that a revocable living trust would be useful apply to you, then we hope that that would be money well spent to draft that trust and to pay that attorney to have a well-drafted, solid estate plan.
Great, thanks. Next question. I have a revocable trust. It is over 10 years old. Should I have it reviewed?
Yes. That's the easy answer, yes. We recommend that you review all of your legal and estate planning documents at a minimum between every 3 to 5 years. As laws change, particularly state laws, some of the documents can become outdated, irrelevant, and need to be updated. So even though it may be what I just referred to as a plain vanilla document, it is always useful to have it reviewed every 3 to 5 years.
Great. Next question. I drafted a revocable living trust while living in one state, but have moved to another state. Is it legally recognized in my new state of residence, or do I need a new one? Good question.
So I think that rather than focusing on the legal recognition of the trust, it would be a better practice to focus on, does the trust make sense in the new state? Is it good planning? Is it appropriate under the new state law? So while it may be perfectly legal, it may still have different implications in different states. So again, this would be a reason to review a trust. We always recommend the 3 to 5 year review, but if there's a major life event or change, such as a relocation to a new state, that would certainly trigger a review. The trust may still be very legal, but it may not make sense the way it made sense in the prior state.
Great. Next question. Are there any tax advantages to placing your assets in a revocable living trust?
So happy someone asked that question. A revocable living trust is not a tax planning device. Because the grantor reserves the right to revoke the trust and remove the assets, the trust assets are still includable in the grantor's gross estate for estate tax purposes. Also, all the income and deductions attributable to the trust property are going to flow back to the grantor. But this retained control also means that no gift was triggered when the grantor places the assets and titles them to the trust. So there's no gift tax for placing your assets in the revocable living trust, but it also does not protect the assets from estate tax because it is still includable in the grantor's estate. However, when the grantor gives up the power to revoke or amend the trust, then a gift will occur. So if they've given up that power at some point in their life or at their passing, then there is a gift tax. So to reiterate, a revocable living trust is not a tax planning device. It is a succession and incapacity planning device.
Great. Next question. Does a revocable trust help you avoid the 5-year look-back aspects of qualifying for Medicaid, or does the trust need to be irrevocable?
Oh, the good old 5-year look-back from Medicaid. Since the trust is revocable, although the assets should be properly titled to the trust, they are still retained in the grantor's estate. And therefore, Medicaid will look at them as owned by the grantor, and that will not satisfy the 5-year look-back. So anything that you've placed in a revocable living trust is still assets that are subject to Medicaid look-back. Even if you place them in a revocable living trust 20 years ago, because you have not irrevocably gifted them and lost all dominion and control of those assets through an irrevocable gift, Medicaid will still consider those assets of the grantor. In order to satisfy Medicaid's 5-year requirement, it does need to be gifted to an irrevocable trust, which of course, as I just mentioned, will trigger a gift and a gift tax. But after the 5 years, if it's in an irrevocable trust, Medicaid will not look at those assets as owned by the grantor. So to sum up, the answer is a revocable living trust will not help you avoid the 5-year look-back when qualifying for Medicaid.
Interesting. Next question. Can you put IRAs, 401ks, and life insurance policies in a revocable living trust?
Wow. Okay, so IRAs and 401ks, let's start with those. IRAs and 401ks are tax-deferred savings vehicles. And during your lifetime, you own them. So they can't be titled to the trust during your lifetime, but you could name the beneficiary of those accounts as your trust. A word of caution, the trust would need to be very, very carefully worded and crafted so that the assets of the IRA or 401k can retain their tax-deferred status. And so, therefore, again, I probably beat this horse to death, but using a qualified estate planning attorney to make sure that special language is contained within a trust if you wish for the beneficiary of your IRAs or 401ks to be your trust, to allow that tax-deferred status to carry on is very important. Absent of that language, they are going to lose that tax-deferred status, and that can be a big loss to your heirs. So they cannot be put in the trust during your lifetime, but the trust can be named as beneficiary so that when you pass, the assets in the IRAs or 401ks can pass to the trust. With life insurance policies, again, life insurance policies are a vehicle that a beneficiary is named. And again, you can name your trust as the beneficiary. Alternatively, you can purchase a life insurance policy where the owner, the person who purchases the policy, is the trust. There's really no greater benefit in a revocable living trust to do that, but you could make it a current asset of the trust and the beneficiary be the trust as well. But there's no tax benefit to doing that, so you could name the beneficiary of your life insurance policy as the trust. The benefit to doing that is upon your death, when the life insurance proceeds pay out, they pay to the trust, and then they pass to your heirs subject to the provisions of the trust. So if you have a spendthrift heir, rather than naming that spendthrift heir as the beneficiary of your life insurance policy, you name the trust, and then the heir does not get an outright distribution of that life insurance policy. Rather, it goes to the trust, and the heir has to seek distributions from the trustee in accordance to the trust document to receive benefits from that life insurance policy and from your other assets.
Great. Thanks, Carrie. Those were some great questions. If we didn't fully answer your question, or if you think of another question later, please reach out to us at wealthmanagement@AAFMAA.com. We'll go ahead and break here for now, but you can reach us whenever you need to. Please don't hesitate to ask for help. This is what we do, and we love it. This weekend, you'll receive a follow-up email with instructions on how to access a recording of this presentation, and you can always sign up for future webinars or review past webinars at wealth.afma.com. If you found this information useful, please share it with your family and friends. Our membership grows stronger every year because you introduce your eligible friends to AFMA. We hope you'll join us again in July for our next webinar. Thanks so much, everyone. Have a great day.